UK court grants Nnamdi Kanu permission to appeal judgment in favour of FCDO. The leader of the Indigenous People of Biafra (IPOB), Mazi Nnamdi Kanu, has been granted permission to appeal the High Court judgment that found that the Foreign Commonwealth and Development Office (FCDO) could lawfully evade reaching any conclusion on whether he has been tortured or subjected to extraordinary rendition and arbitrarily detained. A UK Senior Court of Appeal Judge, Lord Justice Lewis, who granted the permission, said the appeal would be given expedited hearing. Kanu's family had sued FCDO for negligence of duty over Nnamdi Kanu's ordeal, who, though being a British citizen, was abducted in Kenya and extraordinarily renditioned to Nigeria and has remained in detention illegally since 2021. The case, according to Kanu's legal team, has major implications for all British citizens mistreated abroad who may look to the United Kingdom for help. Since his detention, Mazi Nnamdi Kanu's family has been asking the British government to take steps to secure his release on grounds that there was no lawful basis for renditioning him. However, the Foreign Secretary has till date failed to reach any firm view on whether or not the IPOB leader was subjected to extraordinary rendition. The Foreign Secretary claims only a provisional view is possible, despite the mass of evidence and views of the UN and Nigerian Court of Appeal. The family's legal team brought the challenge on the basis that reaching a firm concluded view is necessary to lawfully determine what steps should be taken to assist Mr. Kanu. But a British High Court had, in an unconventional ruling on March 23, 2023, dismissed the Kanu's family's claim for judicial review of the failure of the British government to reach a firm view on Kanu's rendition. The court, presided over by Mr. Justice Swift, however, observed that Kanu was subjected to rendition, but disappointingly held that he had no legitimate expectation that the British government should reach a firm view for itself on what had occurred. Meanwhile, Kanu's legal team described the High Court's ruling as extremely difficult to reconcile with long-standing legal precedents and the principle underpinning it that British citizens can expect protection from their national government. Dissatisfied with the High Court's ruling, Kanu's family applied to the Court of Appeal for permission to appeal the High Court's ruling on the following grounds. The court erred in finding that Mazi Kanu's family did not have any legitimate expectation that the FCDO would form a firm view as to whether Nnamdi has been the victim of extraordinary rendition in violation of the international law. The court erred in finding FCDO's decision not to reach a firm view was not irrational. The court erred in finding that the FCDO is not obliged to comply with procedural fairness standard when considering risk of British citizens as serious risk abroad. Meanwhile, in granting permission to Kanu's family to appeal the judgment, Justice Lewis noted that the grounds of appeal raised important issues concerning the scope of obligation on the respondent in relation to request for consular assistance in respect of British national detained abroad and the proper interpretation and application of the decision of the Court of Appeal in Al-Abasi v. Secretary of State for the Foreign and Commonwealth Office 2003 UK HRR 76. The court further noted that for those reasons, there is a compelling reason for the appeal to be heard within the meaning of CPR 52.6 (1). Permission is granted on all three grounds, citing the urgency rising from the continued detention of Kanu in a solitary confinement. The court ordered that hearing in the appeal be expedited. In a response, Nnamdi Kanu's family expressed delight over the permission of the court to appeal controversial High Court judgment. Reacting to the ruling, Kanu Ntakanu, Nnamdi Kanu's brother, who spoke on behalf of the family, said, "My family is delighted that the Court of Appeal has unhesitedly recognized the importance and urgency of Nnamdi Kanu's case and has hope in our hearts that will be reflected at the hearing and its judgment I am due course." Meanwhile, hearing of the appeal has been slated for Thursday, 22nd June 2023. Nnamdi Kanu has remained in detention at the Abuja headquarters of the Department of State Services (DSS) since his extraordinary rendition from Kenya in June 2021.